Hi, everybody. Welcome back, Chalk and Gavel listeners. Just a quick announcement. Support the show. We would love it if you would rate, like, review, follow. Go to our website, chalkandgavel.com. Check out our merch. You can go to the support the show link on that site and give us a little contribution. Help us run this thing. There's a lot of different ways that you can support us. Write a review. Sign up for our mailing list. Lots of ways that you can reach out and connect with us, and we would love to hear from you. So, yeah, that's just the little shameless plug at the beginning. You wanna start this thing?
I do.
Okay, ask me a question.
What question should I ask you?
I don't know. It's written right there in the script.
I mean, that was a question.
Yeah.
All right, here we go. This is a question we've talked about before, but it's time for a deep dive. Can a state prohibit schools from notifying parents about their child's gender transition at school without the child's consent?
Oh, yeah. Okay, so we've covered this one in a number of bell ringers, actually, but we are back now to give it a full chalk and gavel treatment. So this is the case about parents out in California. Parents and teachers who challenged that California law that blocked schools from informing parents of their kids who were going through gender transitions at school. It also required schools to use students' names and pronouns aligned with their gender identity, no matter what the parents' wishes were. So that got tossed around in the lower courts a bunch in the fall and the winter, and then it got pushed right up to the Supreme Court's emergency docket. So since this is a big one on a number of different levels, we're going to dive into it and give it the full treatment today. This is the case of Mirabelli versus Bonta.
Welcome to Chalk. I don't know if I like that phrasing. The full chalk and gravel, the full chuck and gravel treatment.
Talking cattle, the full talking cattle treatment.
Easy for me to say. What is this show, Jamie?
What is this show? Well, this show, ladies and gentlemen, is Chalk and Gavel. It's where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling you the fascinating stories.
You know what? I'm keeping it in this time.
No.
He does it every time.
Fascinating stories connecting the courtroom to the classroom.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. Alright. The kids are alright.
All right, Jamie. Do you have a bell ringer for us today?
I do. I'm very fascinated about this one, okay? So it's time for an update on a case that we covered like a year and a half ago. Okay?
Oh, yeah, these things work slowly sometimes. Sometimes they don't.
Yeah. Yeah, right? The main case we're talking about today, that was a quick one.
Yeah, like 3 weeks or something crazy.
Yeah, but the one that we're talking about here in the bell ringer, that's a little bit more of the norm in terms of timelines.
Right.
This was a case we covered in our very first live in front of a studio audience cases when we were at the Education Law Association conference in Orlando a few years ago. We recorded this one live. This was the case of a Beebe versus Capistrano. And that was the case, also out of California, that was the case of a first grade student who made a drawing of her friends after a lesson or a unit on MLK or something like that, and wrote Black Lives Matter and then wrote All Lives on this drawing. Remember, first grade.
Right.
She gave the drawing to one of her friends who I believe was an African-American child, and mom got upset and called the school, and then BB, the first grader, was disciplined.
Right. Yeah, there was a lot going on we were kind of inferring that there was a lot going on beyond just this little situation.
Right, exactly. So, according to the court report, she was, BB, the first grader, was told that she wasn't allowed to make drawings anymore and give them to her friends or something. I think they took recess away. She had to have a talk with the principal about how inappropriate her drawing was, or, stuff like that.
Right.
Don't forget, this is first grade. The kid's, 6, 7 years old? So mom took the district to court, alleging that was all a violation of the First Amendment, her kid's free speech rights, right?
Yeah.
So an interesting, silly kind of WTF turn of events. The district court basically said, yeah, little kids are too incapable of having First Amendment rights.
Right. Yeah, I remember finding that really frustrating.
Yeah, you and I had a lovely conversation about that when we recorded that episode about you can restrain speech if it disrupts the school environment, tinker, or if it violates the rights of others, tinker, or if you're 7.
Right. Yeah, exactly.
Right. And so we found that a little frustrating.
Mm-hmm.
So,
oversimplified is probably the politest way I would describe it.
Yeah, exactly. Well, and guess what? The appeals court thought the same thing. Okay, so
all right.
Mom wasn't happy with that earlier decision, so appealed it to the Ninth Circuit Court of Appeals, and that was about a year ago, April 2025 or something like that. And the Ninth Circuit just released their opinion on this in March 2026, and they basically said that the lower court, like we just said, was a little too hasty in their decision. They said that the court downplayed the potential First Amendment rights of young children.
Uh-huh.
Thank you. And they jumped. Yeah, exactly. And they jumped the gun and needed to go back and really deal with the facts. They said, you guys didn't really wrestle with this and clear up some of the facts the way you needed to. So premature adjudication. Sorry.
That's good. That's good.
Okay. So, you know what? How have we done 70 episodes of this show and not used that phrase before?
There are still dad jokes that we have left unexplored.
Okay. Well, look at that. We're staying fresh, folks. Okay. So the court said that age is one consideration in the First Amendment analysis, but it's not the only one. So while the court didn't necessarily decide who wins here, they did say, like you said, that the court oversimplified things. They basically said that, yes, even young kids have speech rights.
Right.
Thank you, Ninth Circuit.
I'm glad somebody's saying it.
Exactly. And they said that they reiterated that students can limit speech, but they reiterated that they can only limit speech if they've got good reasons.
Right.
And like we said, tinker has been sort of the gold standard for that for, over 50 years. It's got to be disruptive. It's got to violate the rights of others. And this court and many others have said just speech that's kind of offensive doesn't rise to those standards necessarily.
Right. We have to tolerate that in certain situations unless it, gets to a certain level.
Right.
Mm-hmm.
Right. So, it just reminds us, and they remind us, that context matters, which includes age, especially includes age. And so since there were some disputed facts, they said, no, we need a trial. They basically said, we're not going to decide who's right and wrong here, okay? Because the facts haven't really been properly fleshed out yet. So, lower court, since you didn't slow your roll when you should have, we're going to slow it for you, is basically
right. Okay. Yeah. So student wins on appeal, but the case is not over. So they won the battle, but the war is still ongoing.
It's still going. Yeah. Like they didn't decide
the merits
on
of the
merits of the
case.
case.
Yep.
Right.
So now let's go back to the trial court to do it right.
Lay out the facts. Yeah.
Okay.
Exactly. So
cool. Well,
that's your update on BB versus Capistrano, who and BB is probably, I would guess 5th grade, 6th grade by now.
Is it that? No. Oh, my gosh.
It was 20,
it could be.
I think it was 2020 or 2021 when the incident.
Yeah. And we'll have another update on that case in about a year.
Yeah, exactly. Once it kind of goes back through the system.
Oh, gosh.
All right. So
what's the opposite of premature adjudication? Because that's what we're about to talk about. Speaking of things going too slow and now going too fast.
I don't know. I'll think of it at some point after we finish recording the episode.
Right. Yeah. That's usually when I come up with my funniest jokes.
All right. Okay. So let's dive into the Mirabelli case. All right. You ready?
Well, I guess this is an example of premature adjudication. So this is the same mistake the trial court made. The Supreme Court's about to jump the gun.
Yeah. I mean, they were asked to jump the gun. I mean, it's maybe the shadow docket should be called the jumping the gun docket. I don't know.
There would be some people who would agree with that characterization.
Yeah. Yeah. Okay. So listen, here we go. As we mentioned at the top of the episode, we've talked about this case before in a bunch of bell ringers, but we need to do a deeper dive. Okay. We also mentioned that this case got kicked up to the Supreme Court and that they were asked to rule on it outside of their normal procedures, which is often called, as we just said, the shadow docket, the emergency docket, right? And Chris, I know you're going to say more and you're probably going to correct me if I'm wrong, which is entirely possible.
It's never happened in the history of this show.
We edit those parts out. But my understanding is that the shadow docket is this expedited version of the Supreme Court review that deals with emergency requests. So there's no like oral arguments and stuff like that, right?
Right.
Like
there's
a
ton of procedure missing. There's no oral argument. There's a tighter briefing schedule. There's less opportunity for deliberation. Like usually the justices sit down in a room, in a conference room, and like argue with each other and decide who's going to go where. But like shadow docket, they just give each other opinions and like write memos back and forth. Like it is a much, much more abbreviated procedure. And
it also sounds messy. Like it sounds like it's just almost.
It is the opposite of deliberate.
So half-arsed.
Exactly.
Okay. So, and it's usually related to things like injunctions or stays, right? Like things that, where people are saying, wait a second, we got to put this law on hold because if we kept this law in place, it could potentially be really dangerous.
Or the opposite. We need to put this hold on hold because this hold would prevent us from doing something really important.
Yeah. And this is where I get frustrated a lot with the law is the amount of double, triple, quadruple negatives that like everybody just seems to love in the law.
The other important thing about these is they're not decisions typically on the merits. They're usually procedural to like decide, which version of the status quo we're going to keep while the case goes on. Right. But they do sometimes get to merits questions because they have to look at like likelihood of success and things like that. So like there's this tension here where like this isn't a full procedure, but we're still kind of like alluding to how we're thinking about the case and, we're signaling how the court might decide.
And we've talked about that signaling kind of stuff before. This is just, I guess, a little bit more of a formal and detailed signaling rather than the kind of signaling that goes on, when they decide not to take a case in Alito.
Like the Alito cheat sheet, with dissenting from denials of cert and things like that. Right. Yeah. Right. Yeah. It's similar, but this actually like has legal effect because it affects, what's going on during the appeal.
Right. So basically, like we said at the top of the episode, the case deals with California's policies around notifying parents and not notifying parents and all of that stuff, right? And it got tossed around in the courts and then it got up to the Supreme Court and the Supreme Court had to decide, do we, allow the law to stay in place or not stay in place? Like who's potentially getting really hurt by whatever is going to be happening one way or the other. And we need to kind of step in and say, all right, while we're answering those questions, here's what the status quo is going to be for the time being.
Right. And that is important, right? It's absolutely important because it affects what's the status quo in California during this litigation. Yeah. But for our purposes, the signaling that the court's opinion does is so important to show how the court is thinking about parental rights right now.
Yeah.
And like, that's why I wanted to do this episode. Cause like, I think there's some landmines in this opinion.
Well, and because what's happening here is this is the highest court of the land that's kind of showing their hand, so to speak, to all of the lawyers who
and
are and other courts who are dealing with these issues and dealing with this case in particular, right? They're saying, okay, here's the argument you want to make, or here's the argument you want to be aware of so that you can counter it, or like all of that is coming out in these shadow docket cases, right?
Right. Yeah. And this is not an easy case.
Oh, no. This is as you will all hear. Like this is my guess is most of you listening to this, you're going to recognize the complexity and the difficulty in this. So here we go.
And the strong opinions held by everybody.
Everybody's got some very strong opinions on this topic. So like we said, the case involves California's policy of preventing schools from telling parents about their kids' efforts to engage in gender transitioning at the school without the child's consent. Okay, so if a kid doesn't give consent, California's law says you can't tell the parents anything. There's also policies that require schools and teachers to use kids' names and pronouns that align with their gender identity, regardless of parents' wishes.
Right.
Okay, so it's a pretty bold law.
It is. It takes children's interests to their logical extreme, right? It says
the expense of the parents' interests.
Right. And it puts the school smack dab in the middle, which is the thing about this that like, schools, if they had their choice, would be like, look, we're not getting into
leave
this.
us alone.
Like, leave us out of this. This is between you and your kid.
Yeah. We want to support kids. We want to make everybody feel safe here so that we can have a great, positive learning environment. Just let us do that, please.
Right. Yeah. And so schools are in the middle. We've got parents' interests on one side. We've got children's interests on the other side.
Right.
It's not hard to imagine a situation where the parent's interest and the child's interest might be different, unfortunately.
Yeah. You've got kids who are teenagers in many cases, right? Preteens. They're developing their own personalities, their own identities. They're trying to figure out who they are. And those kids, as we said about BB2, they have rights, right? They have speech rights. They have privacy rights. They have all kinds of rights. Just because they're a minor doesn't mean that they don't have any rights.
Right.
And
Rights.
Right. Doctor, Spies Like Us. Great movie. Anyway, so listen, do you know of any teenager who wants to be forced to tell their parents everything?
Right. Well, the right to privacy is a very important right, especially because it is core to kind of developing your autonomy, right? Like if you didn't have privacy, how could you do that kind of self-discovery or charting your own course, so to speak?
And exactly. And listen, it's nobody, like we said, this is complicated. Nobody said that this kind of stuff is easy. Nobody, as a parent, you want your kid to have autonomy and develop that and everything, but you want to be there to protect them and you want to be there to raise them, with your set of values and things like that. But at the same time, they need to develop their own set of values and blah. And it's messy.
Right. And this entire case depends on that line drawing about where do parental rights stop and children's rights begin.
Right. Because there's this conflict, right? So we need to kind of identify where that line is.
Right. And that's what the court is doing. They're not calling it that because they're phrasing it in terms of the school's authority and pitted against the parents' rights, not necessarily the parents' rights pitted against the child's rights, which is an interesting framing. But
and
we'll
I
get
think
into that.
And I think that the law, the intention behind the law is, like you said, we're going to take the kids' rights to the extreme. And if there is if there's a potential situation where the parents' views on particular issues might not be supportive of the
or
kid.
where the child just doesn't want to like.
It's just not
risk
ready,
that, right? Because we know that there's a lot of risk in.
There's a lot of risk
coming out to your parents as transgender, as gay, whatever it is. Like, we know that population of children experiences some really kind of profound consequences. Their homelessness rate is incredibly high.
Yeah.
Like there's risk there, right?
There's risk. Yeah, there's risk.
Right. So that's the situation at the heart of this case, right? And
we could probably keep going on the
it's complicated
for a long time, but it's very complicated. All right. So obviously the policies here did not sit well with some parents and teachers in California. So here's who's involved here. We've got two sets of plaintiffs as parents, John and Jane Doe and Poe.
Oh,
that's fun, right?
Convenient that their names rhymed.
Yeah. I don't think those are their real names.
No, I don't think.
Anyway, the Poes had a child assigned female at birth who in 7th grade began to present as a boy. Now, just a little note here, the court opinions do not include these children's names, which is in itself kind of an interesting choice.
Right. It's particularly talking about like the neglect that the court gives to child's rights and interests.
Mm-hmm, exactly. And they also use the pronouns associated with the parent's view of the child's gender. So whenever the court is referring to the kid, they are using the pronouns that the parents prefer.
Female pronouns.
In that case, yes.
In the Poe case.
Yeah. So that's also, it's a statement that the court is making, right? When they do that.
Right.
And listen, just to avoid, we could go back and forth with all this, but just to avoid confusion, we're going to try to avoid pronouns altogether if we can. But if we do use a pronoun, we've decided we're just going to use the pronoun that the child had chosen to use.
Right. And was presenting at school.
Yeah. So anyway, at school, the Poe's child used male names and name and pronouns. During his 7th grade year, no one told the Poes about their child's gender transition. Okay?
Right.
So at the beginning of 8th grade, the Poe's child attempted suicide and was hospitalized. Okay?
Yeah.
According to the Poes, it was only then that they learned that their child had gender dysphoria and had been presenting as a boy at school. A few months after being discharged from the hospital, the Poe's child was again hospitalized due to the risk of additional self-harm. Okay?
Yeah.
So for 9th grade, the Poes sent him to a new school where he again began presenting as a male. The Poes asked the school to refer to him by his birth name and female pronouns, but the school informed the Poes that under California law, they were obligated to use the names and pronouns provided by the child.
Okay, right. So taking the kid's side.
Yeah. The Poes have since placed their child in therapy and obtained psychiatric care. So this is obviously a family that is going through a lot. Okay?
Right. Yeah. And it highlights so many of the challenges of these situations, right? Because shutting parents completely out, at least for them, it seemed like, they were caught off guard by what might have been going on in their child's life.
Right. And we're not, and I'm definitely not going to sit here and make any assumptions about the parents' views or their motivation. These situations can be so complicated for families.
Right.
And so, what we just presented is what we know of the facts, and we're going to leave it there. This child was obviously having a very difficult time wrestling with identity issues and, potentially family, complexities that made things hard. The parents were coming at it from whatever point of view the parents were coming at it from. And I'm not saying that they were coming at it from a unsupportive way. We don't know.
We know nothing about their relationship or the dynamics of the family. That's just not part of the record at this point.
Yeah, exactly. Okay. So now the other family, the Does, they also have a child who in 5th grade began identifying as a boy. In 7th grade, the Does confronted the school principal about their child's gender transitioning, accusing the school of using male name and pronouns for their child behind their back. Okay.
Uh-huh.
The principal explained that the state law prohibited the school from sharing that information about a child's transition without the child's consent. And the Does then transferred their child to a new school and placed him in therapy. Okay.
Okay.
So similarly, we're not going to make any assumptions about,
Right.
uh,
Similar story.
support or not supportive or
Yeah.
whatever. We also have teachers here in this case.
It's not just the parents who are complaining
No.
about this policy.
We've got teachers who are objecting to the policies. They felt like they had to lie or deceive parents in order to follow the non-disclosure requirements of the law.
Right. And
So-
they, also similar to the parents are probably arguing that they have sincere religious beliefs that
Exactly.
contradict.
Right. And
the
we've talked
school's
about that
perspective.
on the show as
Right.
well, right? Like we've covered a handful of other cases with respect to that. So we've got parents, we've got teachers, and we've got a number of different reasons why people are objecting to this law. Okay. So I bet you they filed a lawsuit. Am I right? Did I win?
How'd you know? Because we already talked about it.
'Cause we already- it says it right there.
Right. Right. So they filed a lawsuit in federal court arguing that their constitutional rights had been violated. So the parents, they were arguing that the policies violated their religious free exercise rights under the First Amendment, as well as their substantive due process rights under the 14th Amendment to direct the care and upbringing of their child. So they've got two different claims here. One is based on religious liberties, which we've talked about a ton with things like Mahmoud, but the other one is just based on the due process clause of the 14th Amendment, this idea of substantive due process, which, protects rights that are kind of like significant or essential to ordered liberty or have a, robust historical tradition. They're saying parental rights are a part of that and that these laws violate those rights. And, that I think is going to be the most important part of this whole thing.
Yeah, exactly.
Because, that applies to all parents, not just parents claiming religious liberties.
Right. Exactly.
And the teachers, had similar complaints. They said that the policy violated their religious free exercise rights because it required them to go against their religious beliefs about, the immutable nature of sex, as well as religious beliefs that prohibit them from lying. Because, they saw that not telling parents was a form of lying. The teachers also claimed, free speech rights that said, hey, this violates our free speech rights because you're telling us what we can and can't say to parents.
But also using the terms, forcing us to lie and deceive parents about their children. Like, even though the legal piece is kind of the First Amendment, free speech kind of thing, there's a huge ethical component here as well.
Right. Oh, all of this
All
is
of
like, we're trying to put legal frames on philosophical and ethical debates. And
Exactly.
it is not clean.
No, deeply held personal beliefs, stuff like that.
Right.
It ain't pretty. It
Right.
ain't pretty.
That's why, maybe this shouldn't have been a shadow docket decision. Anyway.
Okay. How do you feel about that, sir?
Yeah, right. Anyway, so the parties engaged in discovery, the trial court granted summary judgment in favor of the parents and teachers. So parents and teachers win at the trial court level, and the trial court entered a permanent injunction preventing the state from enforcing or implementing these non-disclosure policies.
Okay.
So basically, parents and teachers
Law is
win.
done.
In
Yep.
California, they can't forbid disclosure of students' gender incongruity to parents. They can't stop parents from being notified, right?
Right. It doesn't require parents to be notified,
Well,
but it opens the door for districts to develop those kinds of policies and things like that. Right.
It violates their rights to not be notified or to be kept out of the loop.
Yes.
So I think that's an open question about whether or not it does require affirmative notification. because
Yes.
that I think is the next step.
That's the next step.
Right.
Exactly. Exactly.
Yeah. So anyway, trial court says can't forbid disclosure. State appeals that decision. They appeal it to the Ninth Circuit. And while the case is on appeal, because we just found out how long the Ninth Circuit takes to decide cases on appeal with BB, the court says, or the state says, hey, we want an injunction blocking the
injunction.
stay from going into effect.
Yeah.
Or we want to stay the injunction. Excuse me. That's right. And so
Here we go with these double.
this is where things get procedurally a little bit confusing.
Yeah.
So we started with California having its non-disclosure policy.
Right.
That policy was stopped by the trial court.
Right.
Now the state is saying, hey, we want to pause the stoppage. You with me?
Yeah. I mean, it's, you're probably thinking, well, doesn't that mean they just want to put the law back into effect?
Essentially, yes.
And that's yes.
Yes.
That's,
And guess what happened?
I don't know.
The
Tell
Ninth
me.
Circuit stayed the injunction. So they paused the stoppage of the policy. So the original policy is good to go until we get up to the Supreme Court.
Yes.
And at that point, the Supreme Court weighs in. The parents and teachers petitioned the Supreme Court in an emergency basis to vacate the injunction while the appeal is taking place. And the Supreme Court does.
Yes.
So we're back to the point where now the law is being stopped. It's no longer
It's on
enforceable.
hold.
Right. But interestingly, the Supreme Court only granted relief for the parents.
Oh, that's
It
right. I
only
remember reading
lifted the
Yeah.
injunction in terms of the parents. So there's nothing here about teachers
teacher.
and what teachers, can or can't be required to say.
Yeah.
So, the bottom line of the Supreme Court's decision is that the trial court's order preventing the state from not notifying parents is no longer in effect. It's no idea what this means for educators because
the court stayed out of that.
the stay of the injunction in terms of the educators is still in effect. So the court strongly signaled that parents have a right, or at least, can't not be told about their child's gender transition at school. But as of now, there's no guidance on what that means for school personnel and what they may or may not have to say.
Mm-hmm. Mm-hmm.
So I want to dig into the opinion because this is we already said this isn't creating precedent. It's not binding law, but it's still giving us a really good sense of where this stuff might be going. And so the opinion of the court, and this is pretty typical of shadow docket opinions, was written per curiam, meaning opinion of the court by the court. So there's no named author. However, this is where things get fun because I can count to 9. You ready? So we've got a concurring opinion by Justice Barrett that was joined by Roberts and Kavanaugh. It's 3 so far. We have a dissent by Kagan that was joined by Justice Jackson. So now we're at 5. Mm-hmm. And we also have statements that Alito and Thomas would have gone even further and granted the application in full. 7.
Oh, so basically to include the teachers.
Right. Yeah.
Okay.
Yeah. They have no qualms with anything that the district court said.
Surprise.
Right. And then Sotomayor would have denied the application in full. So she would have gone even further than the dissent does. So we've got 8 justices. We know what they wanted to do. We're missing one.
Gorsuch,
Where's Justice Gorsuch? Well,
Yeah.
my guess is he wrote
golfing?
the per curiam opinion.
Oh, he wasn't golfing. Okay.
No, everyone participated. And there's only one justice whose name isn't assigned to a position. And there's a per curiam opinion for the entire...
Which means it's by the court,
right.
not
So,
by one particular...
I'm speculating here wildly. But I think Justice Gorsuch wrote the per curiam opinion. And I think that's really interesting because of what the per curiam opinion does and what it doesn't do.
Mm.
So if we're counting votes for future cases, I think that has huge implications.
Sure.
So ostensibly, the court isn't supposed to make new law on the shadow docket, and they're not supposed to create binding precedent. But that line has gotten a little fuzzy as the court's conservative majority seems to be using the shadow docket to advance some novel interpretations or even revisiting existing law. And this is one of those examples. So that's why counting votes is going to be really important because it kind of tells us where the justices are and where they might be going. So how did the court's majority come to the decision to lift the stay and allow the stoppage of California's non-disclosure policy?
Wow.
That's a great question. It's a very short opinion, but there's a lot to unpack here. So we're dealing with an injunction. So the court starts with likelihood of success on the merits. So this is one of those situations where like they're not making a decision on the merits. This is whether or not they're likely to succeed, right? So they're still getting to the merits. And so, you know, while they say things like, you know, it violates parental rights, they always put the word likely in front of it. So it's not a definitive statement, right? This is a conjecture.
Yeah.
Right? Except if you take the word likely out, I think that probably tells us where we're going to end up. Right? So, you know, in the words of Dumbledore from Harry Potter.
Oh, yeah. Harry. Let's go.
From this point forth, we shall be leaving the firm foundation of fact and journeying together through the murky marshes of memory into thickets of wildest guesswork.
Oh, I love it.
So I just want to put that caveat out there, right?
Yeah.
I am reading tea leaves here. Because none of what the court says here is a definitive interpretation of law.
Okay. I think that might have also been our first Harry Potter reference.
No, that's impossible.
Really? No, I think it is.
Oh, well, we got to work on that.
Right. Somebody will probably let us know.
We have absolutely talked about it because I remember talking about the wand I got in like middle school on the show. Okay. So, all right, that's your homework. Somebody go find that reference.
Somebody go find out if we talked about this before. Okay.
Right. So starting with the parents' religious free exercise clause, this is really interesting. The court treats it as a straightforward application of Mahmoud versus Taylor.
Wow.
1-to-1.
Really?
Yeah.
It burdens their religious freedom?
Right. Yeah.
So
that's 100% it. Like, parents have a right to guide the religious development of their children. This places a substantial burden on that. Therefore, just like in Mahmoud, bing, bang, boom, parents win.
Sounds simple enough.
It does, but that is a broader interpretation of Mahmoud than maybe I had.
Wow.
Right? Like Mahmoud was talking about curriculum. If this is how they're understanding Mahmoud, that means Mahmoud applies to every policy, procedure, practice of public schools that might implicate parents'
religious
desired religious upbringing. And that is huge.
Yeah, that opens the door really, really wide.
Right. That could have massive implications.
The floodgates, as they say, potentially opens the floodgates.
Right. Yeah. So they're adopting this expansive view of Mahmoud, which is going to affect how other courts interpret Mahmoud, right?
Exactly.
And then, there's a couple other things that I think are really interesting here. The way the court phrases what is happening here, I find really telling. So the court says that, quote, uncontested facilitation of a child's gender transition by schools is what intrudes on parents' free exercise rights. And that unconsented facilitation of gender transition, I don't know if I would characterize it that way, because it sounds like
school in a very active
role, right? It's not like it's saying that like, hey, the school is actively involved in, what the child is doing. And like, that's not the reality. Like, in many situations, I think the school is just like, don't put us in the middle of this.
Yeah.
Like, what if they're just trying to stay out of it? What if they're trying to be Switzerland? They're just trying to be neutral.
We just want to know what to call the kid.
Right.
Like,
we got to call them something.
We're not trying to facilitate their transition or whatever.
Right.
Like, just what do we do to make sure that this kid is safe and comfortable?
Right. And, in a sound learning environment where they feel like they can be who they want to be. Right. Like that's
right. But, so that unconsented facilitation is that's doing a lot of work.
A ton of work. Yeah.
Wow.
Yeah. And then the other part of the decision that I think is really interesting is when the court was deciding whether or not the state has a sufficiently compelling interest to override the parental rights here, the court says the state does have an interest in student safety. So that's important.
All right.
But that California's current policies, quote, cut out the primary protectors of child's best interests, their parents.
Interesting.
Right. I think that quote is really, really important.
But it's not every kid's primary protector is not their parent.
Right. And that's why they say the primary protector, because that implies that there's not, the parents aren't the only protector,
there are
right?
other protectors.
But I do think, I don't necessarily disagree with that statement. I don't like, but it does show the court's thinking about how it's, theorizing this relationship between the state, the child, and the parent.
Yeah, and
parents' rights,
who's in which tier of the
right? Yeah, parents' rights are by far at the top.
Yeah,
as the way they're thinking about it, like they're so strong that neither the child's nor the state's interests can overcome them, except in very narrow circumstances. Because the court goes on to say that, quote, the state's interest in safety could be served by a policy that allows religious exceptions while precluding gender identity disclosure to parents who would engage in abuse. So like that recognizes there are situations here where like somebody needs to protect this child from their parents and where the court would kind of elevate those interests above parental rights. But like, I think that framing is really, really interesting because
there's a lot of parents' rights laws out there that do that will go sort of, I know of a number that go the opposite way that say you have to inform parents except in situations where you have a credible reason to believe that would put the child at risk.
Right.
So they have had exceptions.
Right. And that seems to be kind of an assumption that the court is operating with, is that like by respecting parents' interests, we are protecting children's best interests unless we have a reason to not think that.
Yeah. So it's coming at it from a different angle. It's,
right.
Like I can see them potentially saying, it's almost like they're potentially saying, listen, we hear you, but there's a different way to go about doing this. And
right.
And it's one extreme versus the other.
Right. Well, and that's kind of the thing is like, we've got important interests on both sides of this equation. So it's really a question of like, how do we balance these interests and recognize all of them at the same time?
Yeah.
And that's not what the Supreme Court is doing with this language, right? No. And it's also not what California did, to be fair, but like
100%.
It's hard.
It is.
Right. And so, that's the religious claim, but we've also got these claims that aren't based on religious liberty, that are just based on parental rights. And this to me is where the court makes the biggest leap. Though it's not as far of a leap as the concurrence by Justice Barrett would have gone. No. And so that I think is really interesting. Like this is actually the less significant or the smaller step, if you will, than what the concurrence by Barrett joined by Roberts and Kavanaugh would have done. And so again, counting votes, I think is really interesting because that's three conservatives who, maybe would have taken parents' rights even further.
Right.
So the court says that, under long established precedent, parents, not the state, have primary authority with respect to the upbringing and education of children. So again, parents, not the state, again, showing that hierarchy, and that those rights included the right, quote, not to be shut out of participation in decisions regarding their child's mental health. And the court says that because gender dysphoria has important bearings on children's mental health, not telling them about it violates parental rights to direct the upbringing and education of their children.
Okay.
Two interesting things here about that. One is the per curiam opinion never mentions the idea of substantive due process. It never says parental rights are fundamental. It never talks about applying strict scrutiny or anything like that. So like that is already pretty interesting because that's what the concurrence by Justice Barrett would have done. It would have said like, hey, this is a fundamental right under the due process clause. The state can't survive strict scrutiny. We're applying substantive due process. None of that is in the per curiam opinion, which is probably why why Gorsuch didn't join Barrett's opinion. But again, wild speculation. But, to the per curiam opinion, to support this conclusion that parents can't be kind of shut out of decisions relating to their child's mental health, they cite this case from 1979, Parham versus JR. And this isn't an education case, but I wanted to highlight it because it highlights something that I think the court is doing consistently in these parents' rights cases, which is looking at existing precedent and kind of not missing the point, but ignoring a lot of the nuance.
Okay.
because in that case dealt with whether or not parents could voluntarily admit their children to mental hospitals for care.
Okay.
So like involuntary admittance, child doesn't want to be admitted to the hospital.
Yeah.
Parent says, hey, I think you should go get some help.
Right.
And the court said that parents could do that.
Okay.
But they said that because of the risk of error inherent in parental decisions to have their child institutionalized, because that risk is so great, there had to be some kind of inquiry by a neutral fact finder to determine whether or not statutory requirements for admission had been satisfied. So yes, parents have a right to involuntarily admit their kid to a hospital.
Right, but to avoid, if you want to make it kind of like, it's akin to the innocent until proven guilty, right? Like we've got all these protections to make sure that our system doesn't like automatically screw over somebody who's innocent.
Right.
We need to similarly have some protections in the event that parents either are going to make the wrong decision
choice for their kid. Yeah.
Or are doing it, for the wrong reasons or
right.
Yeah.
Right. So it recognizes that parents aren't solely responsible for making decisions about children's best interests, and that, there could be a disconnect
between
are you saying the parent's version and the child's version, or what someone else might understand as the child's best interest.
So are you saying that they referenced that case but left out the mediating factor that was such a critical?
They cited that case for the proposition that parental rights include the right not to be shut out of participation in decisions regarding their children's mental health. That was the proposition they cited that case for.
But wait a second. Like, isn't the whole idea behind, what this law was, or what some people would say this law was designed to do, was to protect the kid from the parent who is potentially going to not be supportive or something like that. So if you reference that case, but you leave out that big caveat from that case, which is, yeah, parents, you can do this. You have the right to do this, but we have to put this other safeguard in place to make sure that everything's okay. That seems like a little bit of an omission.
Right. Yeah, because it ignores the other interests that were recognized explicitly in that case.
In that case, exactly.
Yeah. Right. And, that's one of my big critiques of the Mahmoud decision, is that it does the exact same thing with like Wisconsin versus Yoder, West Virginia v. Barnett, Tinker v. Des Moines. Like, it takes all of those and somehow comes out with like parents have exclusive control over children.
Yeah.
And I don't think that's what those cases say. So, all that to say, the court decides that parents are likely to win this on the merits. And then it goes on to balance the interests at stake here, because that's something we have to do in injunctions. Like, you have to be likely to win on the merits, and then, we have to balance the equities or balance the interests. And the way the court balanced the interests here is really, really interesting, because the court says, quote, and I think this is probably the most important quote in the whole thing, because it shows how the court's thinking about this. The court says, quote, everyone agrees that children's safety is the overriding equity. Children's safety is the overriding interest.
Okay.
It goes on to say, and the injunction here, the one that prevents California from enforcing its non-disclosure policy, promotes child safety by guaranteeing fit parents a role in some of the most consequential decisions in their children's lives.
Fit parents?
Fit parents, one, that's already a telling thing, right? Like, there's a fitness requirement here.
Yeah.
But it says children's safety is guaranteed when parents participate.
That's a big assumption.
It is. And, it's basically equating parental participation with child safety.
Yeah.
And so, we see again, children interests are being subsumed by parental interests.
Right.
And, that's a larger concern that I have about this whole parents' rights conversation, especially with the current Supreme Court, is they're ignoring or completely subsuming children's rights and interest into those of their parents. And, we talked about it before. We've talked about it in other contexts. We talked about it with BB. Like, children have independent interests and rights that need to be protected by the state, sometimes even in opposition to parental rights. Mm-hmm. And so it's a line drawing issue about like where do parental rights end and where do children's rights begin. And the Supreme Court so far has shown no inclination to even consider that line.
Wow.
Yeah, I know. That's why this opinion is really interesting.
That's crazy.
Yeah, because
So-
that's something they're going to have to grapple with.
Yeah,
unless
yeah.
they keep ignoring children's interests.
Okay, so where does that leave us, or at least where does that leave the Ninth Circuit, right? Like all the states who are in the Ninth Circuit right now. It's essentially like the court has said, for the time being, the state cannot keep parents out of the loop. You can't have a policy that actively hides things from parents. It didn't really say anything about whether or not your policies have to affirmatively inform parents.
Right.
But it basically opens the door. Like if there's a district in California, for example, that wants to do that, they are supported by the...
Right, because California can't enforce its no disclosure policy at this point.
Right.
And that's the only practical implication of this
what
decision.
about I think that there's a practical implication, though, for teachers as well, though, right? Because they didn't rule on that, it kind of means that teachers still have to follow state and school policies. And if that guidance is to use students' names and pronouns aligned with their gender identity, technically, this does not say...
Right.
Because we didn't rule on that.
Well,
right?
and the parent or the teachers here were only, at this point, we're only talking about the parental notification piece, not necessarily the pronoun policy. And so, yeah, like the technically the injunction is still in place there for teachers, but like if you can't not tell parents, who's going to tell them if not school employees, right? So like it's unclear how that's all going to play out. So yeah, like this is not a final decision.
Right.
There's a lot of ambiguity here.
Right.
But we're going to keep reading the tea leaves, and I think we're going to see more parental rights cases, and these things are going to get messy, and they're probably going to get messier. I think like if this opinion shows anything, it's that Mahmoud may have only been the first step, particularly if the court goes the substantive due process route, which applies to all parents rather than just the religious route that it used in Mahmoud.
And that's such an interesting thing, because when Mahmoud came out, we were like, it didn't go so far. It wasn't so massively extreme. It went further than I think a lot of people hoped it would, but like it wasn't like, hey, this is the most game-changing decision. But now we're starting to see cases that use Mahmoud and interpret
that are
it.
taking extremely expansive interpretations of Mahmoud.
Right.
And then that's going to bleed over from the religious liberty line of cases to the substantive due process line of cases.
Right.
And
and it's happening in so many different areas too. Like it just happened with the Fifth Circuit's decision on the Texas 10 Commandments law, right? Like they are interpreting Kennedy in that case in a much broader way. They're basically saying, Kennedy threw out the Lemon test, and therefore Stone versus Graham in 1980, which
all
is
the cases that dealt with Lemon are no longer good law.
No longer good law. So basically, like, I mean, they're taking some of these cases and they're really blowing them up. Right.
And that's like part of the doctrinal signaling that goes on with these cases is like, this is how we're thinking about it. And like, hey, that's going to have implications for these other cases. Go buckle your seatbelts. So like, yeah, we are in the middle of a shakeup. I think, we called it a sea change in our South by Southwest remarks. But like the court's expanding parental rights doctrine, it's really reshaping, and like the religious doctrine, all of the things that's going on right now, like it's reshaping educational governance.
Exactly.
And like whose voices should be heard, and how we govern schools.
It's big. And I think we're going to see over the next 5 or 10 years is a lot of these really complicated cases play out across the country. And then my guess is in many cases, the Supreme Court as well, we're going to see those very complicated cases start to land on one side or the other. We're already starting to see that. We're starting to see the signaling, right? That is going to propel those cases to one side or the other. And that is going to codify the educational governance. A lot of what we're seeing sort of starting to shift is going to start to be solidified.
Right. Yeah. And we know which way the court is going. The bigger question is, where are the lines?
Well,
and we're starting to
see where they're drawing,
where they might be drawing those lines, right? Because like the religious charter school, that is a great example of like, we've got this line of cases that says religious freedom requires you to treat religious schools like you treat everybody else. And you can't treat them worse because they're religious.
Right.
And then there was this charter school that wanted to be religious. And we know at least one conservative justice
that
sided with the liberals and voted against that. So like that could be a line. We don't know though, because it was only 4-4. Right. So yeah, like and it's going to be an interesting time to be having a school law podcast.
It is. And it's, and the other thing, the last thing I'll say is like the fact that these cases take so long to play out, right? It makes the makeup of the Supreme Court so critical because some of these cases might not hit the Supreme Court for 3, 4, 5, 6, 8, 10 years, right?
Right.
And by then the court's makeup could be very different. And, you know, it's that's one of the reasons why you hear in the news that, you know, the Trump administration is trying to get, you know, Alito and Thomas to retire so that they can, you know, put in some younger,
more aligned, whatever it might be. Yeah.
People are trying to shape the Supreme Court because it has such a huge impact.
Right.
For a long time.
Yeah. And we talk about judicial advocacy, and this court has been so active in reshaping jurisprudence.
Yeah. Yeah. Okay. Well, I'm going to go have a drink. All of this premature adjudication. Okay. What's our homework?
I think we already gave you your homework. Your homework is to find where else in Chalk and Gavel we have mentioned Harry Potter.
Harry Potter. That's
I think we have, and Jamie seems to think we haven't.
Yeah. Who's right?
Right. And so please go prove me right. But in addition to that, go like, rate, review Chalk and Gavel. Your reviews are so important to helping us be elevated within these algorithms and to spread the word. And, you know, we just love hearing about what you all think of the show. That means a lot to us. It helps us a lot as we continue to develop and refine the show. So please engage with the show. Social media, we have a feedback form. You can find us on our website, chalkandgavel.com. Check out the merch. We've got some fantastic merch that we probably had way too much fun creating. And you know, keep the conversation going.
Yeah. All right. Well, we'll see you back here in 2 weeks, folks. Have a good one, everybody.